I'd like to call this meeting of the Board of Revision to order. I'd like to begin by acknowledging that we're in Treaty 1 territory in the traditional homeland of the Métis Nation. My name is Lynn Nesbitt and I'm chairing our hearing today. Other members of the panel with me today are Brent McIntyre and to my left, and Stu McPherson joining us by Zoom. Gail Anderson is also seated at the table and she's observing the meeting today. Our secretary is Michelle Neepin and our assessor is Jamie Fouget. To the participants of the hearing, please note you are placed in the waiting room until your property is called upon. When it is your turn, you will be admitted into the meeting. Kindly follow along on the City of Winnipeg's Board of Revision YouTube channel for the hearing process. Once the host admits you into the hearing, please close or mute your YouTube player. You will then be permitted to speak with respect to your property. Once your hearing has concluded, you can leave the meeting. We will be hearing applications for revision of the assessment roll in accordance with the Municipal Assessment Act. The matters for which revision is requested have been described in each application, and we will limit discussion to those matters. The statements that are made at this hearing are sworn testimony, and anyone speaking to the matters must be sworn in. Be advised that comparisons of assessments of properties are not considered evidence of market value by the Board of Revision. The Board of Revision is appointed annually by Council and is independent of it and the City administration. It makes its decisions on the basis of the evidence provided at this hearing and issues a written order that will be mailed to all parties as soon as possible. Please note that the Board's decisions with respect to an application may be appealed to the Manitoba Municipal Board if the matter pertains to assessed value or classification, or to the Court of Queen's Bench if the matter pertains to the application of exemptions from taxation. Should you wish to appeal, information on how to do so will be included with the Board's order. With respect to the hearing process, I'll confirm the points of appeal with your property to be addressed with each applicant following the swearing in. We will then have the assessor's testimony followed by questions that the applicant may have, and then the applicant's testimony followed by questions. Each side will have an opportunity to summarize if they wish. Once all of the evidence about an application has been brought forward, the applicant may leave. The process will repeat for each item on the docket today. The session will close after all the applications have been heard, and the Board will deliberate in private and make its decisions. You will receive the Board's decision by registered mail as soon as possible. As information, all public hearings are live streamed, recorded, and will be part of the public record. First on our agenda today is 2979 Pembina Highway. Owner is Rockport Investment Group, Inc.
Mr. Trudeau, before we get started, I will, oops, sorry, I guess I have to come back in the room. I would hope.
Mr. Fouget, first I guess we'll have the swearing in of the applicant and the assessor.
Mr. Fouget, I'll swear you in first, please. Can you state your full name?
Jamie Fouget.
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Mr. Trudeau, I'll affirm you in before we get started.
Sure.
Can you state your full name, please?
His legal name, David Jeffrey Trudeau.
And do you affirm that the evidence you're... Sorry? Do you affirm that the evidence you're presenting today will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Thank you very much. I understand that for this property, we have an appeal of the assessment, the assessed value of the property. Is that correct?
Yes, this one we're starting with 2979 Pembina?
Yes.
Perfect. Yeah.
Okay. Mr. Fouget, you can start.
Okay. So good morning, everybody. As mentioned, the property here that we're starting with is 2979 Pembina Highway. The roll number is 030602901100. So this whole docket actually is a little bit unusual for a couple of reasons. As you guys know, the province basically extended the 2020 assessment cycle to include the year 2022 as well. So it's 2021, and 2022. And here, actually, each property on the docket has been appealed before for the cycle. And I believe every property on this docket also had an agreement with the owner or the agent representing the file. And so we're in a bit of a position that's not something that happens regularly, for sure, where we've come to an agreement and then the owner has decided to pursue the appeal for the following year. And my understanding is they're in the right to do this. But I did just want to touch on this quickly. And this sort of goes for all the properties on the docket today. That it's not something that we would like to see, because when we come to an agreement with the owners or the agents representing the owners, it's expected that we've settled the matter. And I think it's generally in everybody's best interest to try to stick to the agreements for the cycle, for a number of reasons. And I think each party, the board, the assessment department, and the owners, I think it's important to have that faith in the agreement that you've undertaken, because I'm sure the owners wouldn't want us to renege on our agreements. Again, unless something happens to the property, for example, a demolition or new construction, those I think would be clear reasons to deviate from the settled value. But we don't have any of that here today. So I just wanted to touch on that point and let my perspective be known. But having said that, we can continue on with the first property on the docket here.
Thank you.
So as mentioned, it was 2979 Pembina Highway. And I'll just refer you to the pictures of the property so you can get a sense for it, which are on page 9 of my brief. So this is effectively a 2-story strip mall type of building on South Pembina. And you can see some overhead shots on page 10. So as mentioned, this is a property that had an agreement on it.
Mr. Fougere, I just need to ask you a question.
Sure.
On the front page of your brief, you note that you're requesting the burden of proof be placed on the applicant. Is that the case?
Yes. This is a message that comes up automatically when the owner is non-cooperative with the income and expense questionnaire. In this case, I'm not seeking it. It was already awarded and not bought.
Okay.
The last
That's good.
field.
Okay, that's great. Thanks for clarifying. Continue on then with your evidence.
Sure. So I mentioned that we had an agreement at the Board of Revision for 2020, which again is still in this cycle. And just going to refer you to page 5 of my brief. So you can see here, this is an approximated breakdown of the Board Revision recommendation. Unfortunately, it was a verbal recommendation at the hearing, and we did not have an actual breakdown of how it was directly put together. But this is from the best of my understanding from the notes that were taken. And so the original assessment was reduced, and it's been reduced down to $3,346,000. So that's the number that is under appeal today. And again, the owner has appealed the number that was agreed to by the agent that was representing this file in the appeal for 2020. So that's the number there. And it's going to take a look on page 19. If you wanted to see, we have the order from that hearing, basically saying that the non-cooperation penalties were applied. And I should note that they weren't challenged by the agent. And then you can see on page 20, it shows the value change from $3,824,000 down to $3,346,000. So just very quickly, since it's already been covered here, on page 11, down to page 18, we have the evidence that was brought in for the non-compliance penalties that we sought, that we sought at the time. And I should also note that we have not received a mailer since 2015 for this property. So we are lacking some information on some of the particulars of the property. We've also sent out a sales mailer request, which has not been returned. And the owner, Mr. Trudeau, and I have chatted a couple times, and I let him know that I was interested to understand more about the sale that occurred in February 8th, 2017. You can see on page 2 of my brief, we have a sale that has gone through land titles with a sworn value of $3,100,000. And so that's actually during the reference period. And so I had also emailed Mr. Trudeau a copy of the sales questionnaire so we could try to verify the sale for the purposes of this appeal. Unfortunately, he wasn't able to return it to me. So we still have some lingering questions around that sale price and whether or not it was a good bona fide sale. But as we see here, there's a sworn value of $3,100,000 during the reference period. And I'd just like to point out on page 3, I have my rental comparables. For South Pembina here. So, I would like to know more about the sale. Unfortunately, without this information, I can't recommend any further reduction. until we can confirm the parameters of the sale. But even at our assessment of $3,346,000, I think given the fact that we don't have any information on this property, I think that's a fair assessment. That's my presentation.
Thank you, Mr. Fougere. Mr. Trudeau, do you have any questions about what the assessor has presented?
Just made some notes here. At this time, I guess, am I able to ask a question about the cycle here now that it's included 2022?
Right.
Yeah. Right. So, I mean, of course, we know we had I believe it was in 2019 they came out. Our representative came out and came up with these agreements that we saw nothing. Again, it was verbal, so we didn't know what they were agreeing to. We just got a bill in the mail. Says, here we go. We've done this. Pay us, right? So, and then it's my understanding, like, yeah, you're usually locked in for those 2-year cycles, which I believe it's, simply because of COVID that all of a sudden now we've included the 2022 assessment year, which is obviously, why we're now here trying to further get these reduced. It's not our intention to say if we agreed to something, we want to go outside of that, but we see, obviously with what's been going on out there, businesses, going under, rent not being collected, things happening that when we're seeing these things, we want to come and try and have the opportunity to renegotiate, obviously, some of these numbers as well as with the information that we've put on. So I just wanted to clarify that is something that was added after, and it's typically, right now we should be having that opportunity to renegotiate the 2022.
And do you have a question of Mr. Fougere?
No,
the information he's presented?
Nope, it's all pretty straightforward here.
Thank you. I'll ask the panel members now if they have any questions. Mr. McPherson, do you have any questions?
Just a couple. I noticed that the order that you presented, that it was a verbal recommendation and the decision was based on that verbal recommendation. But I don't see anywhere where it says that the applicant was in agreement with that necessarily. But do you know the circumstances behind that? Were they in agreement?
Yes, they were in agreement. And I know that from just tuning into the streaming of the hearing. And so I was able to confirm that they agreed to the figure at the time. And if it's of any note, just with reference to the agent and the agreement that we have here, the sale price did not appear in their brief, so I don't know if they were potentially unaware of the sale. And of course, I don't want to speculate on that, but it wasn't something that was discussed in the hearing, and I wasn't able to see it in the applicant's brief.
I see. And I see it was a different agent, but I'm not familiar with Mr. Trudeau. Is he with the same agency?
No, I believe Mr. Trudeau is part of the ownership group of
Okay.
this property.
Okay. And the 2017 sale that you're talking about, did that trigger an inspection by the assessment department?
I'm not aware of that, no. I don't believe so.
And would you happen to know when the last time an inspection took place?
From watching the hearing for this property, the assessor at the time representing the city had a chance to inspect the property. I've been there myself, probably a little while back, probably 2014 or so, in a couple of the units.
Okay. All right. Thank you, Madam Chair. No questions.
Thank you. Mr. McIntyre, do you have any questions?
I have no questions.
Okay. And I don't have any questions either. So, Mr. Trudeau, you can begin your presentation, please.
Thank you. Can everyone hear me okay? Excellent. So thank you all for coming out and hearing me today. My presentation, obviously not as pretty as the one provided by the City of Winnipeg, but first time. So let's dive into it. So I mean, I provided, obviously we were basing ours off comparable sales, recent sales. These are all now 2021 with what we were able to dig up for similar properties, similar square footages, and around the city and what they've gone for, right? So obviously on my notes here, we've provided a chart with 6 different properties, some which we were able to find the sales information on, which I mean, typically, when we're evaluating something, when we're acquiring something, or when we're even selling something for a client or anything like that, that's where you base where the market's willing to bear. Right now, I do understand that this is now work talking about 2018 numbers, which kind of would help our case to seek some further reductions, because I don't think real estate was as valuable back then. So we've provided some recent sales with a mix of properties, some strip malls, office mixes, and everything like that.
Mr. Trudeau, I'm sorry to interrupt you.
No, it's all good.
I just wanted to point out to the panel that this information is post-reference. And so I would ask that it be dismissed as evidence from the hearing.
Thank you. Mr. Trudeau, the information that you have presented the sale information is post-reference. A reference date for this cycle is April 1st, 2018. So do you have evidence that reflects 2018 values?
I do not know, because I was not made aware of that until literally the day that I submitted this information.
Okay. Do you have anything else that you can present us about your property specifically that would warrant a decrease?
Nope, just basically what I was led to believe I was to provide.
Okay. Mr. Fougere, do you have any questions of Mr. Trudeau's evidence or what he said?
I don't have any questions on his presentation. I would like to inquire about the sale price that I had touched on in my presentation. If you're able to, Mr. Trudeau, give us a bit more information about the sale, whether or not it was between arm's length parties, if it was a open market transaction.
Yeah, no, it was an open market transaction. Obviously, it was a bona fide sale for $3.1 million. That's the number that was registered through land titles, which all of you can see. It was on the MLS late 2016. Went conditional, I believe it was mid-summer 2016, with that closing date of early 2017 for the $3.1 million.
Okay. Do you know if there was an appraisal done at that time?
There would have been back in 2016.
Okay. Okay, those are my questions.
Thank you. Mr. McIntyre, do you have any questions?
I have no questions, thank you.
Mr. McPherson?
I have no questions, thank you.
Okay, and I have no questions. So that concludes our hearing on 2979 Pembina Highway. Next on our agenda is 1031 Autumnwood, and I just want to clarify, Mr. Fougere, that also this recommendation that's on the brief to request burden of proof, that was for the last appeal, doesn't apply to this specific one. Is that correct?
Correct. Again, it's auto-generated because this is the same cycle.
Okay, thanks. So then you can begin with your presentation.
Right, so the property here that we have next is 1031 Autumnwood Drive. The roll number is 060446345500. And again, this is a property that has been appealed prior. And this one actually, there was an agreement by way of 15-1. So we don't typically.
Just for clarity, can you describe what 15-1 is?
Sure. So a 15-1 agreement is it's a section of the Municipal Assessment Act which allows the assessment department and an owner or a representative for the owner to come to an agreement to settle an appeal. And so when you've settled it through a 15-1 agreement, at that point, the appeal is withdrawn. And I don't believe you have a chance to appeal it any further, for example, to the municipal board. And with these agreements, I should also say that we have an understanding not to disclose the details of the agreement out of confidentiality for the parties involved. Having said that, now that agreed upon settled number is appealed, I don't see any way to discuss the appeal without having some reference to the number that was agreed upon and the details of how it was arrived at. So you can see that details of the agreement on page 5 of my brief. And so the most important thing I wanted to point out here is that it was agreed to a number of $3,266,000. And it was the same agent that represented the property as the last property that we looked at. And to see the property, you can take a look at starting on page 9 of my brief. So there's some pictures there. So there's 2 buildings. There's one larger building that has Trailblazers as one of the main tenants here. And then there's a Circle K, formerly Max, as well as sort of a pad site closer to the front. And I don't think I need to go into it, but on page 11 is the information that we had for the non-compliance. And so this property also sold, but it sold a little bit earlier. So this property sold January 21st, 2013. And my understanding is that this was a good sale, that this was a bona fide open market transaction. And it sold for $3,120,000. But that's in 2013. And so our reference date is April 1st, 2018. So I had just taken a look, and this isn't in my brief, but I've taken a look at the Bank of Canada's website and took a look at the inflation from 2013. So according to Statistics Canada Consumer Price Indexes for Canada, on a monthly basis, if you type in 3,120,000 in 2013, you would arrive at 3,307,000 in 2017. So I use 2017 because our reference date is April 1st, 2018. So to be fair, I've just bumped it back a little bit. However, you can see based on that information that on inflation alone, that figure would be somewhat comparable to the agreement that was made at the Board of Revision, or sorry, I should say prior to the Board of Revision in 2020 when it was appealed. So I think, especially in cases where we have signed agreements, I think it's important to try to stick by those, especially when the evidence, in my opinion, is suggesting that that was a good agreement and that bears some support from the sale that is there. Another assessor obviously agreed on it, that passed through our department, had supervisors sign off on it. The agent agreed to it with their expertise. And I obviously can't speak to how that might work between the owner and the agent. But generally speaking, I think an agent would hope to be acting in the best interest of the property owner when they come to agreements like this. And as I say, 15-1 agreements are usually sort of the end of the road. For example, you can't appeal a 15-1 agreed upon figure to the municipal board. So to find us now relitigating the value here, I think it's maybe not a great precedent to set. I know that agents are very competitive for trying to attract their clients, and when we go into an agreement, there's an understanding that the matter is settled, and in some cases, partly because we want to move on from what we've done here. So, an agreement is a statement saying that this appeal is settled. But let me just take a look here. The last thing I'll say is that I have comparables here on page 3 of my brief. And the first 3 are just at the neighboring property at the front. The 2 in the middle that are 414 Westmount Drive are in the same neighborhood, and they're also it's a strip mall basically within a neighborhood, and not on any major roadway here. And then there are a few other ones that are in the same vicinity. At any rate, that's my presentation. Thank you.
Thank you, Mr. Fougere. Mr. Trudeau, do you have any questions of Mr. Trudeau's evidence?
I do actually, yes. I guess I first want to ask, the 15-1 agreement, how long is that in effect for?
I don't know that there is any end date specified, but they last the cycle. And I also point out that this was an agreement that took effect in 2021 because there was we didn't receive a mailer from the owner.
So what? It's simply because there was no mailer, it took effect, and it didn't take effect in 2020 when it was agreed to?
It did not take effect in 2020, but it took effect January 1st, 2021. Mm-hmm. And that's following the legislation around the penalties for non-compliance with the request for information.
Okay, gotcha. So realistically then, I mean, this is, if there's no end date, I mean, it's just not common practice to then appeal when a 15-1 is in place?
I'm sorry?
They said, so if there's no, locked in date cycle, well, I guess, yeah, you said it's for the cycle. So depending on what that cycle is, then that's basically what it's frowned upon to come and try and push back. Okay. That question, then the question with respect to the rent comparables. So I'm just looking at the ones on Autumnwood here. are these rental rates, were these from back in 2016, or are these current rates for 2020 or 2021?
So you can see in the middle here, we have the lease start date.
Mhm.
And so the leases would have been signed just prior to that.
Okay, and
those dates.
So in 2016, they're getting $17 a square foot. That is in fact the face value in 2016, or was this like a step up rate situation? Sometimes landlords will look and step up the rates as years go on.
Right. We do try to differentiate and make that determination that it's not a step up.
Mhm.
Sometimes that information may not be provided by the owner of these properties. I have taken a look at these, and as far as I can tell, they are all absolute net signed in and around these lease start dates.
Okay, I would just want to make sure that we're actually comparing the actual, if these were back then, or if these are now rates that we're referencing for the current year, which is not what
Right.
Right. Okay. I think that's my only questions on this proposal.
Thank you, Mr. Trudeau. Mr. McPherson, do you have any questions of the assessor?
Just a couple, and it's mostly procedural stuff, I guess. You said that request for the onus to be shifted, that's an auto-generated field that just comes up. Can you not redact that after the fact?
We could. I opted to just leave it in because it is a reminder of the lack of information that we have and the circumstances surrounding our attempts at assessment here. And it is noteworthy that we have not received a mailer on this property since 2011. So we've had quite a few years in the interim with no information from the owner. Now, granted, a couple of those years would have been a different owner because there was the sale date in 2013.
Okay. And just clarification on a 15-1 agreement. I was just checking the municipal act, and I don't see anything here where it states that it's for the cycle, which is what you said. Is that not just for the appeal year that it was filed, and they have an annual right of appeal? Is that not the case?
Yes, I should say it's for the cycle insofar as assuming nothing changes, that value will remain in effect for the remainder of the cycle. So, for example, when we sign the agreement, in 2020, had this not been an agreement that had the deferral penalty applied, it would flow through from 2020 to 2021. And so we would have established that as the value. At that point, the owner can appeal it, evidently. We're here today. I was not aware of that, but in terms of it preventing them to appeal a subsequent year within that cycle, I should clarify my language and say that that's not what I intended to say. And I believe that this is a valid appeal today.
Okay, I thank you. And just further, the 2013 sale, you said that if you adjusted that by I believe you said the CPI or a cost of living, is that a normal practice versus, say, taking actual increases or decreases in the market itself?
Right. So it was just an exercise to illustrate that if you ignore any market increases which have existed, that amount alone is equivalent to higher than the assessment that we have here today. So I mention it only for illustrative purposes. I know that increases annually are probably in retail properties are probably closer to the 10 to 15% annually, and this was 5 years prior to the reference date. So arguably, when you consider the market, it should be higher, but we have this agreement, and I'm defending the agreement that we have in place here. And I think that even if you look at it with no increase, with zero, I think it's a fair number that we have assigned.
I thank you. Thank you, Madam Chair. Those are my questions.
Thank you. Mr. McIntyre, do you have any questions?
I just have one clarification on the CPI or Consumer Price Index. Does that not take into account just goods and services?
Yes, that's where I believe the information is derived from, and I don't I don't want to rely on this for my presentation, and it's something that I'm presenting verbally, but I mean it only as a reference point, to get a sense of how dollars from one period of time to another can change comparatively, if that makes sense.
But it does not include real estate, does it?
Right.
Okay, thank you. That was my only question.
Thank you very much. Mr. Trudeau, we'll hear your presentation now.
So actually the presentations I provided, we did use the same comparable properties, obviously, which is kind of interesting that we're looking at that CPI information, because as you can see, I mean, if we want to talk inflation, all of our sales here, granted they're not from the 2018 date, they're all 2021. If you take that average cost per square foot, we're actually looking at less than what the agreed upon amount has been. Again, same thing as before. We've come up with some comparable properties, as you can see on the 6 that we've provided, the recent sales, as well as our chart breaking down their square footage, the asking or sale price that we were able to find, and then further breaking that down for the average cost per square foot. Not as in depth as the Board of Revision summary provided by the City of Winnipeg, but we're going to get better at this. So realistically, I mean, we've just come up with, again, other comparable properties that have sold in today's value, which, I mean, again, when you break it down, would show a lesser value than what we have, what is being currently assessed at even years ago, right? That's basically it in a nutshell.
Thank you. Mr. Poujart, do you have any questions?
I do have a question. I'm just going to take a look for a moment, if I may. You know what? My question was going to relate to some of the evidence that Mr. Trudeau is mentioning, but I think maybe it's best that I just leave it where it is, because, again, I don't think that necessarily those properties are comparable, and most importantly, they are outside of our reference date. So I don't have any questions. Thank you.
Okay, thank you. Mr. McPherson, do you have any questions?
I have no questions, thank you.
Mr. McIntyre?
And I have no questions, thank you.
Okay, and neither do I. So thank you very much, Mr. Trudeau, for coming in today, and you will receive our decisions very soon by mail.
Thank you very much.
Thank you very much.
A short break, please.
Yep, and we're just going to break for about 5-10 minutes, and we'll be right back. Good morning. I'd like to call the meeting back to order. Good morning, Mr. Reimer.
Good morning.
We'll get you affirmed, and then we're ready.
Can you state your full name, please?
Carrie Reimer.
Do you affirm that the evidence you're about to give at this hearing should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you. We'll now go to our agenda. Item number 3, 560 Pembina Highway. Mr. Fougere, when you're ready.
Okay, so property, as you mentioned, is 560 Pembina Highway. The roll number here is 120-152-11500. And so this is another property. Again, as mentioned, all the properties here have been appealed in a prior year for the same cycle. And this one here was agreed to with a value of $11,966,000 between myself and a representative from Altus as a recommendation at the hearing. So I'm just going to have you turn to the breakdown that I had sent this morning, which is actually a bit of a correction from the one found in my brief. So there's actually 3 documents that I have for this hearing. I believe the first one is titled with the ending copy 1 of 2.
All that, or do we just have the one?
So if I can just interrupt for a moment, Jamie, the document that you sent this morning has already been switched. So the panel is looking at only that document. Yeah.
Okay.
So they just have the 2 documents now.
Okay. All right. Well, my apologies. So I believe what you're looking at is entitled then Breakdown for 560 Pembina Highway. Is that correct?
It says 560 Pembina and then recommendation at the top.
Right. Right. Yeah. So unfortunately, I don't have the exact figures that I had used for our recommendation in the hearing. But this is a reconstruction that having had a chance to look at the numbers again, I think this is very fair. It's based on actuals. And I've basically, there was 3 income streams prior, and I've put it all to 1. And so we have 4% vacancy and capitalization rate of 7.3. Something that I've also done here is I've gone through and I've taken a look at the non-recovered expenses over the past few years. And if you will wait with me just for a moment. So from 2018 down to 2007, I've taken a look at the non-recovered expenses. And
Mr. Fougere, is this in your evidence?
This is not in my evidence.
Okay. I have some difficulty with referring to an analysis that isn't in evidence, though. So I'd object to the inclusion of that.
It's
Go ahead.
can I not include it as verbal evidence?
I'd suggest, Madam Chair, that verbal evidence, I have no ability to review the evidence and to present questions and/or concerns. I'm not comfortable with the inclusion of that at this stage.
We'll just break for a little minute and have a discussion here and get back to you both. Thanks.
Thank you.
Okay, I see Mr. Fougere, Mr. Reimer, you're on mute. If you could thank you. We're back in session. Mr. Reimer, we've considered your objection to the verbal evidence. We will proceed with hearing Mr. Fougere's verbal evidence, and you'll be given time to ask questions of it. And the panel will be putting appropriate weight on that verbal evidence. So, Mr. Fougere, you can go ahead.
I was just mentioning that for the purposes of defending our position here, which we had previously made a recommendation that was agreed upon in the hearing, the total number being $11,966,000. As part of my review and support for that, I did take a look at the non-recovered expense for this property, basically over the last 10 years. And there's a couple things that stood out to me. One was the relationship between non-recovered expense and vacancy, because it was frequently a large portion of the non-recovered expense was bad debt and unpaid operating expenses. As a result, I believe, from vacancy. Regardless, though, I was able to see that with the vacancy, and the first point is it becomes difficult to untie the non-recovered expenses from the vacancy. But I was able to see that there appeared to be a larger than 2% non-recovered expense at this property. And I had calculated a median of 4.89 as non-recovered expense. And that was at a time where there was not a lot of vacancy. And it also seems to fit looking through the records here. And I know this is anecdotal, and I know I don't have my analysis in front of you guys. So please take it as what it is, as verbal evidence, as my testimony. But our department hasn't changed on the position of the 2% expenses. But I will agree that from property to property, some may be higher than 2%, others may be lower. And in this case, I believe that 5%, as a way to arrive at the agreed upon figure from the last appeal, which again is in the same cycle, 5%, I believe, made sense with the numbers that I was seeing. So I'm going to take a look at my second brief here, which should be effectively the brief that I went to hearing with in 2020. So just opening the brief here. And before I continue, I should mention that on page 27 of my brief, for 560 Pembina Highway, you can see some overhead pictures of the property. So you can see Tim Hortons pad site, Domo pad site, and then there's the strip mall at the back, a portion of which has a second story. And it's a pretty popular kind of intersection there. High traffic. You're probably familiar with it. And then I'm just going to take a look at the income and expense or the rent roll that was submitted to us. And that can be found starting on page 18. So on page 18 here, you can see in terms of just the straight rent, they've reported $895,769.91. If you take off all of the expenses here, just get down here. So even if you remove all of the non-recoverable expenses, you arrive at $839,959 as the net operating income. And then if you look at the breakdown that I have for our valuation last appeal, again, within the same cycle, we have a net operating income of $862,372. Now, there is a difference there of about $30,000, or not quite, but say $25,000. I think that can be explained in part by the pad site of the Tim Hortons. So the Tim Hortons is on a land lease. And so you can see in my breakdown here in the recommendation, the last unit here on my list at 2,300 square feet, I've given a rate of $27.80. And I believe the land lease would work out to being about $20. So we've topped up that land lease to reflect, the full bundle of rights for the Tim Hortons. And finally, you can see we have the gas equipment of $153,000 added in there as well. And so we get to a total of $11,966,000. And I just want to say, more broadly with my approach here, I think we routinely see, or it's common to get site specific at the board of revision. And, we often, all parties are very interested in what the actual leases in place are, and what the actual income is at the property. And so I understand, looking to the market to support your expense breakdown. But I think there's also value now that we're site specific to look at what's actually happening specifically at the property. And that's what I've attempted to do here with some recognition that the expenses were higher. So that's my presentation. Thank you.
Thank you, Mr. Fougere. Mr. Reimer, do you have any questions?
I do. Thank you, Madam Chair. Mr. Fougere, and I appreciate you sent the corrected valuation down, so I'm going to refer to that first. I got it by separate email, so it's just a one-page document. So the final value you're suggesting is 11,966,000, correct?
Correct.
And that's, we can agree, of course, sounds a little trite, but we can agree that this value is supposed to be the market value as of the reference date, which in this case is April 1st, 2018.
Correct.
Right. And you alluded to it, and I agree, when we're conducting these appeals, what we're attempting to do is to look at the site-specific information, what an investor would know as of the reference date, and then value it accordingly, correct?
Correct. I don't want to anticipate where you're going with this, so I'll just leave it at that. What we're valuing is, as of the reference date, what was known and what would an investor place on the income value would they place on the income stream, if that helps to clarify that. We can agree on that component. Generally, yes.
Okay. Now, I'm not going to belabor it because the position of the department concerning what we're calling the non-recoverable is very well known. So you, in this document, to be fair, what you tried to do is reconstruct the value previously agreed upon, and you've applied under the category other, you applied an overall percentage of 5% of the effective market income as your way of looking at some of the site-specific information, correct?
Right, and I've done it in such a way to be more illustrative. I could have taken off of the rents and suggested that these are not fully true net rents and gone about it that way. And I want to be absolutely clear that I have faith in our expense analysis. We've gone site specific here, and this is how I'm choosing to reproduce our recommendation that was adopted.
Sure. Yeah. No, that makes sense. Now, conceptually, though, we can agree that the shortfall expense line at the $8 a square foot, that's the intent of that expense is to account for basically carrying costs for vacant space in a given year, and it's tied to the vacancy allowance, correct?
Correct.
And then, depending on your position, and I've heard you loud and clear, but what you've classified as other, historically, I'll put it this way, historically, the department prior to 2020 had included two expense categories. One was labeled with the term management at 5%. The other category was labeled other at 2% and the percentages coming off of the effective market income. We can agree that was the department's processes prior to 2020, correct?
Correct.
Okay. Now, you had made a very brief comment about the difficulty in sort of splitting out the categories of non-recoverable. So can I ask the board members and Mr. Fougere, and I don't know how to describe this. This is the brief number 2. So your original 2020 brief, if we could go to that brief and then go to page 20 of that, those materials, please. And Madam Chair, if you can let me know when you're all there.
I'm there, Madam Chair.
Titled Pembina Grant Junction Income Statement.
Yes.
For the period ending December 31, 2017.
Indeed. Yeah.
I'm there.
Okay, we're there.
Okay. So the top, Mr. Fougere, these are your verbal evidence. These are the expenses that you referred to that you had looked at for the past 10 years for the subject, correct?
Correct.
Okay. Now you mentioned a difficulty splitting out, and you mentioned it being tied to vacancy, but we can agree that, and this is an example, and again, Mr. Fougere and Madam Chair, I'm suggesting that this is in fact the case. This is how the income statements for this particular owner are set out year in and year out. So this format was followed each and every year. So Mr. Fougere, the leasing commissions, the TI allowances, and there's no mortgage in this case, or mortgage processing fee, but the consultant's fee sundry, like these are all separately laid out, correct?
Correct.
And so the vacant, what we are labeling or we're suggesting, as we discussed earlier, the shortfall, which is the carrying cost for vacant space, those would actually be very clearly set out under vacant unit gas, vacant unit hydro, as far as the utilities go, correct?
Correct.
Okay. Now, I am going to go, okay, so Madam Chair, I am now back to Mr. Fougere's corrected valuation, which I have as the one page, showing the 11,966,000. And Mr. Fougere, the department had originally, and you again, for the purposes of this hearing, you've applied a vacancy allowance of 4%, correct?
Correct.
And that's for all. Previously, just to clarify, previously this property, I believe, had 3 income streams. You've combined them into one, so it's 4% applied to the entire income stream from all sources.
Correct. And in my analysis, that also is more fair in terms of the overall vacancy of the property going back within those 10 years, in my opinion, in my analysis.
Sure. Now, so we can agree, though, and I briefly alluded to this earlier, but we can agree that what we're completing when we're valuing the property is a prospective analysis based upon the principle of anticipation. So we are, of course, going to consider what's happened in the past, but we're also very interested in understanding what the future benefits are, and that's the principle of anticipation and appraisal theory. So that is, in fact, what we're trying to do this morning, correct?
Our department seems to take or disagree with some of the concepts that you mentioned there with anticipation, insofar as we're looking at a snapshot of the value at the reference date, not necessarily using cash flow analysis, for example. We're using the direct capitalization, and I understand that. Anyways, I'll let you continue. Sorry.
No, that's okay, Madam Chair. Those are my questions. Thank you.
Thank you, Mr. Reimer. Mr. McPherson, do you have any questions?
I guess just a couple. Did I hear you correctly? You said that it's still the assessment department's stance that 2% is sufficient for non-recoverables for the majority of properties, but on a case-by-case basis, you can reconsider that number?
Insofar as trying to isolate a net operating income that has a relationship to the net operating income of the property itself, the statistical analysis, I believe, is tried and true surrounding the 2%. As I mentioned, we routinely make adjustments to rent, and an adjustment could be made to the rent in lieu of using the 2% other category, because there are a variety of different items that fall into the non-recoverable label, and some of that could easily be, for example, leases that have property tax recovery, at a fixed point, say based on 2013 levels. There's different items and different lease points that could make it such that the non-recovered portion is simply not fully recoverable expenses, if that makes sense. Meaning that you know, there's two ways you can net it out. You can either do it up front and find out what the true net of each of these lease rates is, or you can use it in an expense variable or field.
I see. Okay, and I can appreciate that every year is a new hearing based on the decision based on the evidence that's presented. But you seem to be stressing previous agreements in most cases. And I just looked at that agreement. I don't see anywhere where it mentions that it was agreed upon. It was just accepted. Do you know
Right.
it was agreed upon? Were you the assessor of record at that?
I was the assessor, and it was agreed upon. And you know, part of that, you can take that for what it is. Sometimes the orders will specify that it was accepted by the applicant, and sometimes it doesn't.
Okay. So is it fair to say that the value of $11,966,000 was what was agreed upon and not necessarily the methodology to get there?
Correct. Absolutely correct.
Okay, and I will be asking that of the applicant as well. So I know I'm kind of jumping around, but Mr. Reimer, is that your understanding as well?
That would be correct based upon the respective positions, specifically on the non-recoverable issue for sure. Yep.
Right. Okay. Thank you. Sorry to go out of order there, Madam Chair. That's my only question. Thank you.
Thank you. Mr. McIntyre, do you have
And
any questions?
I have no questions. Thank you.
Okay, thank you. Okay, Mr. Reimer, you can begin your presentation, please.
Thanks, Madam Chair. And I'm going to not apologize, but I'm going to ask for the board's and Mr. Fougere's indulgence because of the nature of this hearing and the comments that have been made by Mr. Fougere, and certainly they're well received, but we have a different view on the matter as to why we are here this morning with respect to these appeals. I have sent Ms. Neepen a copy of the Court of Appeal case of Motor Coach Industries. Ms. Neepen, could I impose on you please to forward that to the board members and Mr. Fougere? And Madam Chair, if you might let me know when the orders are available and open to you.
What year was that from, Mr. Reimer?
This court case was decided in it had to do with it's a 1997 year, and it would dealt with a 1995 order. The principles haven't changed, but it's from roughly 24 years ago now.
Yes, thank you.
While the board's, I'll just quickly describe the circumstances in this case while the board is getting this decision. This was a case where it was an appeal within the same assessment cycle at that time. There were 4-year cycles, and an appeal was filed in a subsequent year, and the city assessor at that time filed the previous board of revision order, previous board order as evidence of value. And so the questions that arose is, can the assessor rely upon just that order as prima facie evidence of value? And the more important question, though, for our purposes, relates to the annual right of appeal that Mr. McPherson has alluded to. Madam Chair, do you have the case?
Yeah, we have it, Mr. Reimer.
Okay.
It's a separate document. Did you receive it, Jamie?
Yes. Yeah.
Okay, so if I might ask the board and Mr. Fougere, please, to turn to page 6 of the decision. And there's a highlighted section after they define the issues and the questions to be addressed. There's a highlighted section towards the bottom of page 6, and it says section 56.4. Now, this was a municipal board appeal, so the section numbers will relate to that board, but it's the very same principles that apply to this board. Section 56.4 of the Act states that a party is entitled to a full hearing before the board on the issue raised, in this case value, and in our case is value, as if the issue was being heard for the first time. The Act does not explain what is meant by a full hearing, nor does it state how the hearing is to be conducted. The ordinary words used in 56.4 mean that the hearing before the board is a hearing de novo. The board is not to make its decision on the basis of the evidence heard by the Board of Revision. It must hold an independent hearing at which evidence is presented. Then moving on to page 7 at the top, the scheme of the Act directs that assessed values are to be carried forward during the years between general assessments. However, in their collective wisdom, the legislators recognize that circumstances, both anticipated and unforeseen, may affect value from year to year. Hence the provisions of sections 13.1 and 14.2 and the annual right to apply for a revision. The board is required to hear the evidence of value to consider the quality of the evidence called and, at the end of the day, to decide whether the onus on the assessor to prove value has been satisfied. And then now I talked about the previous board order, and there's a little highlighted section 2 paragraphs down, right at the end of that paragraph, that says a board order made during the currency of the same assessment cycle may be considered by a subsequent board as prima facie evidence of value. We take no issue with that. Mr. Fougere is absolutely correct, and that's, but the key concept here is prima facie evidence of value. So if upon the submissions in a subsequent appeal within a given assessment cycle, the evidence needs to be considered independently and fully by the board, notwithstanding the previous board order. Now on page 8, at the second paragraph, the court states successive boards, Board of Revision and Municipal Board, do not sit as appellate tribunals from the decisions of previous boards. The board sits as an appeal tribunal hearing cases de novo from the decisions of the Board of Revision. It must hear all the evidence of value that a party chooses to present to advance his case. The evidence which a party presents to the board is not confined to new evidence which was unascertainable at the time of the previous hearing. The Act places no limitation on the evidence to be heard by the board. Since the right of appeal exists on an annual basis, it follows that the board may annually be required to conduct a hearing and make a determination of value on the same property. If no new evidence is presented, the board may also be entitled to reach the same conclusions on value as did a previous board. However, the board is also entitled to consider differently the same evidence heard by a previous board and determine value on its view of the evidence. Part 4 of the Act deals with assessments and the revision process. In enacting Part 4, the legislature recognized that the valuation of realty is not an exact science, that changes may occur from year to year, and that some flexibility must be maintained in the process. The stringent test set out by the Supreme Court for the introduction of new evidence in civil appeals, very different scenario, has no place in the valuation and revision process established by the Act. The appeal of a civil case from the decision of a trial judge to a court of appeal cannot be compared to the appeal process from a board of revision to the board, meaning the municipal board, or to repeated applications for revision. By providing a party with an annual right to apply for a revision and obliging the board to conduct a de novo hearing, the legislation requires the board to admit all evidence of value, whether heard by a previous board or not. All of this to reinforce, Madam Chair, and Mr. McPherson has alluded to this, and I want to be very clear though, there is in the legislation and through these court cases, there's a very clear annual right of appeal. So that is a starting point I'm suggesting, and I understand that the department's I'm sensing a sense of frustration by the department. I understand it, but I'm going to explain in the context of this case why I'm going to suggest that that frustration perhaps isn't as well founded as it might otherwise be. When going beyond the court case to the present appeals, then, so when you've got a previous appeal, there's a number of things that can happen when you've got a previous appeal. You can have new evidence that comes to light. You can have a change of circumstances. You can also, pardon me again, you can also though have different agents. And to be clear, I will never consider myself, Mr. Fougere's outlined some different circumstances relating to these appeals. In this particular case, Altus Group was the agent for this owner in connection with the previous appeal. In the other cases, however, Altus Group was not the agent involved and had no input into the discussions, nor whatever agreements were done, Altus Group was not a participant in those processes. So with respect to the role of Altus Group, we're going to at all times provide our clients with the very best advice we have, regardless of any previous appeals within the cycle. And if we come to a different value conclusion, we expect, if the client agrees that it is worth pursuing, we do expect the board to take our appeals very seriously, both for legal reasons, but also practical reasons. Our conclusions, simply put, are different. And to suggest that somehow that those subsequent appeals in this context are not appropriate, I with respect to Mr. Fougere, I don't buy it. Here's the other thing, and this is the thread that runs throughout all of the appeals this morning. The board can appreciate that when an agreement is undertaken between two parties, whatever the agreement might be, the rights, obligations, and expectations of both parties are specifically set out in the agreement. And because if they're not, the agreement isn't binding. So Mr. Fougere has correctly pointed out that under the legislation, when one does a 15-1 agreement, or for that matter, in a practical sense, when you have a value that's agreed upon in the previous appeal hearing, one of the fundamental terms, in addition to an expectation of what the value is going to be, one of the fundamental terms relates to the length of the agreement. And in all cases, the length of the agreement very explicitly at that time was known to be 2 years. The province, and as I understand the situation, this didn't involve the city assessor, so I can't comment on it one way or another, but what is clear is the province unilaterally changed that fundamental term. They went from 2 years, and they without notice, without warning, without consultation, obviously, to these owners or anyone else that we're aware of, they changed the term of the agreement from 2 years to 3 years. That is a unilateral fundamental change, and what we're considering to be what effectively amounts to a breach of the original terms. So while I understand the frustration that the department's got with these situations, we would not, and I'll be blunt on this, we would not be here if the province hadn't unilaterally decided to change that fundamental term to extend the length from 2 years to 3 years, which was not agreed to by the owners and which was not a part of the original agreement. So while, again, I have the greatest respect for Mr. Fougere and members of the department, I fundamentally disagree with the premise that somehow these appeals are sort of a question of bad faith. If anything, I'd suggest the extension of the agreement by a full year. That is not good faith. So, having said all that, what do we have in the case of the subject property that we're dealing with first? This is 560 Pembina. And I won't go through all the details that Mr. Fougere has presented. It set forth this is the strip mall located on Pembina Highway. And in this case, if I could ask the board members and Mr. Fougere to open up our evidence in chief, the 36-page brief. And when you're to that stage, if I could ask you to go to page, and I'm reading the page numbers directly from the Adobe file, not the page numbers as shown on the brief, to page 13 of our main brief, which has the valuation summary. And Madam Chair, if you might let me know when you're to that stage, and then I'll continue.
I'm having trouble finding it too.
I am too.
No, I missed it. Right into the, yeah.
Yeah,
They go right into the income statement.
so do I.
Seem to be missing some pages, so just bear with us.
Certainly.
I don't know.
No, it goes from the covering page to page 16 right off the hop.
Ms. Nepen, would you like me to email another copy?
I'm just checking right now to see the original. Look at that matter. We only have page 2 of the municipal court order as well.
Yeah.
Sorry. Oh, no, it's 1. No, it's 1.
For the quarter revision?
Oh, no. I don't know. I don't know what we're looking at. Yeah, we only have 1 page of that too. Yeah, we'll just have a quick recess while we look into this.
Thank you.
Okay. I'd like to call the meeting back to order. First, I'd like to thank you for your patience as we work through a technical issue. We now have the entirety of Mr. Reimer's presentation. So, Mr. Reimer, if you can direct us again to the proper page.
Thank you, Madam Chair. If I could ask the board members and Mr. Fougere, please to turn to page, and again, this is the PDF page number, not the page number as shown on the brief. It's page 13. And what you should see then is an income approach summary with a chart with 3 income streams.
Income approach summary dash total property.
Yes, indeed.
Got it. Okay.
Okay. So there's a few things that I'll point out with respect to this property. The potential rent that we're applying is actually, it's not hugely different, but it's actually about $9,000 higher than Mr. Fougere has presented. And again, granted, Mr. Fougere was reconstructing a valuation based on the previous events. So we've actually applied $971,000. The differences in the valuation for this property, the primary differences are the vacancy allowance, which we have specifically placed on what had formerly been a separate income stream for NSC, which is Neighborhood Shopping Center. What that is basically the property other than the Tim Hortons and the Domo Gas Bar. So that's one of the differences. And of course, the other difference is the application of the 5% non-recoverable expense allowance, the restoration of that allowance. We're not disagreeing with the addition, the factor or the addition of the gas bar improvements, 184,000, that's the same. And the shortfall amounts and the rate for that had been historically applied as other or structural allowance of 2%, we're applying that as well. So I had suggested earlier that there were very specific reasons in all of the cases on the docket this morning as to why Altus Group has filed these appeals. In this case, as I alluded to, we were very involved, and we are obviously the agent for the 2020 appeal, and we're very active in that appeal. But here's what happened, and this reinforces the annual right of appeal that the courts have reinforced. When the application deadline for the 2022 appeals was coming up in June, we had a chance to speak further with the owner, and he brought to light, he expressed some concerns with respect to some of the tenants in the mall that were the space was not physically vacant, but there were extremely dubious circumstances surrounding these tenants that resulted in a very high degree of uncertainty. So, Madam Chair, the reason that we are here this morning concerning this appeal, one of the primary reasons relates to that vacancy allowance that we're suggesting. If we go just a few pages up in the brief to my page, to page 7 of the PDF. And at the bottom of page 7, what you'll see is that the average vacancy rate in the mall, there's a little chart there, in the 5-year period leading up to the reference date is 6.66%. It was actually 0. It was fully occupied for a brief period of time in 2015, but of course in 13 and 14, as you can see there, it was substantially higher. And then in 16, it started to creep up again to 4%, finally ending up at 6.3% in 2017. As of the reference date, it was just slightly lower at 6.26% based on the vacant area of 3,149 square feet. But if you then scroll to the next page, and these are the concerns, the specific concerns, and some of the specific items that we considered in the context of this appeal. Foster's Shoes, under bullet point A, Foster's Shoes occupied 1,090 square feet under a very short-term 1-year renewal. And I'd suggest to the board that when you're talking about renewals of 1 year or anything 3 years or less, but especially with 1 year, that is an indication of a tenant that is that there's very little stability and a very high degree of risk involved with that tenancy. landlords are typically going to want a commitment of 5 years or more. And when you start getting down into the 1, 2, and 3 years, that is just simply not a good sign and a sign of an elevated risk. In this case, Foster's Shoes occupied that area of 1,090 square feet under a short-term 1-year renewal, and they left at the end of that renewal in August of 18. There was no specific letter that was given to the landlord prior to the reference date, but the conversations the landlord had prior to the reference date, I'm told, indicated that it was very clear that they wouldn't be renewing again in August. Joey's Only Seafood, they're a significant tenant here. They've got 2,400 feet. They, of course, are part of a franchise operation, and they were in serious difficulties concerning its, with respect to its franchise and the landlord was aware, based on some incidents prior to the reference date, that there was a significant chance that the franchise would be terminated with the operator due to the conduct of that operator. And again, the covenant in those circumstances that were known as of the reference date was tenuous, I suggest, at best. Achilles Foot Clinic, they have 678 square feet in Unit 202, had specifically not agreed to a renewal of anything exceeding 1 year. Again, very much calling into question the viability of that tenant. And finally, PharmaSave, another substantial tenant occupying 2,146 square feet on the second floor, had specifically declined the landlord's request for a 5 or at least a 3-year new renewal. And the tenant had made the landlord aware that its substantial reductions in its operations were in progress because of the reduced footprint that had been continuing to shrink of PharmaSave locations in the province. At the end of the day, they only agreed to a 2-year renewal, and it was only after substantial efforts made by the landlord to get that much out of that tenant. So these weak tenants, these very tenuous tenants, occupied a total of 6,314 feet. That represents 12.5% of the area in the NSC, which is Neighborhood Shopping Center. If you add that to the existing vacancy, then we're talking about 18.8% of the area. So very, very substantial. So based upon all of that, and these are specific circumstances that we're bringing forward to this board now, going beyond what was physically vacant, but taking into account all of these serious concerns, we're suggesting 7.5% as a vacancy allowance to the NSC Neighborhood Shopping Center income stream. The other significant item that I've mentioned is the non-recoverable expenses. So, Madam Chair, if I could ask the board members and Mr. Fougere to refer to our non-recoverable expense study. And for the sake of brevity, I'm very familiar with all the panel members and Mr. Fougere. I would not propose to go through this in a whole lot of detail unless the board would like me to do so. So, Madam Chair, I ask yourself and the board members if they recall this submission previously and if a very detailed presentation is required, or if it would not be particularly helpful to review it in detail at this stage.
And I'll ask my colleagues, do we feel a need for a refresher on this, or are we comfortable with it?
I'm comfortable.
Yeah, it's fairly fresh in my mind. Thank you.
Thank you. You can just go ahead, Mr. Reimer, then.
Thank you. I'll sort of have it at the 30,000 foot level then. And Mr. Fougere, I believe he's very familiar with this study as well. So as I mentioned earlier, the original, prior to 2020, there was a label placed on this allowance, and it was called management. And it's an extremely misleading label, in my opinion, and in our opinion. What the allowance was always intended to relate to was non-recoverable expenses. On page 3 of this document, we quote from the assessor's valuation procedures manuals, where they say, even with net leases and competent management, there still will be expenses incurred by the landlord that are non-recoverable from the tenants. That's what we submit the allowance relates to. And as the board might recall, there's a plethora of non-recoverable expenses, some of which are never considered, such as mortgage interest, but many of which should be considered in the valuation of the property. And they include some of the larger ones that tend to come up are leasing commissions, advertising, and professional fees. And also going further, of course, there's the ongoing expenses of the landlords in actually getting tenants and securing tenants. Now, I'll just make a very brief reference to it. If you go to our page 12 of the study, which is the chart, And what you'll see on that chart, there's two columns actually. There's a chart. The first column is the showing the percentage. What we did fundamentally, again, just to refresh the board's memory, we looked at a 3-year period for the non-recoverable expenses so that we could come up with a reasonable stabilized amount. And that over the 3-year period, we then stabilized it in two manners. One was just with very specific expenses of leasing commissions, advertising, professional fees, and where applicable, it doesn't come up often, but at times, asset management fees. Then we also went through and added an additional column where you include the tenant inducements. Now, to be clear, the municipal board, and I'm sure the panel members will recall this, the municipal board has said you cannot take TIs off of the face rents to come up with what amounts to net effective rents. To be clear, that is not what we're suggesting. That's not what we're doing. We understand that guidance very well. But what one has to do, though, is take a look at the expenses that are actually being incurred and are non-recoverable in terms of viewing how the expenses impact the stabilized expenses impact the income stream in the future. And so that last column, as you can see there, includes the tenant inducements, tenant incentives, and it, of course, results overall in a much, much higher number for an average and a median. Once you factor those into account, it's actually closer to a 12% average. If you even ignoring those items, if you look at the properties on this chart, our average is 7.42%, our median is 5.75%. So effectively, we are suggesting that the assessor had it right originally, prior to 2020. They had it right. And now we believe they've understated a stabilized expense allowance, and we're suggesting it should be restored. It's very fair to say, and I appreciate Mr. Fougere's diligence in this case with respect to his review of the income statements. There is simply no doubt, and you'll see I won't go through it all, but you'll see if you choose to go through some of our attachments, in some cases, in some years, these non-recoverable expenses amount to almost nothing. They can be as low as zero or something very close to zero, but they can also be extremely high. If you've got an owner that has got significant vacant space and he is paying leasing commissions to lease that space, some owners amortize the leasing commissions over the term of the lease to match the expense to the revenue. Some owners just report the leasing commissions paid in a given year entirely in that year. And that's when you will see a very substantial spike, typically in these non-recoverable expenses that can reach, as I show on the chart, well into the double digits. So as high as 31% and 54%, depending on which set of assumptions you use. So it can be very high, but we believe at the end of the day, the 5% is very justified and should be restored. The only other item I'm going to add, and this is now going outside of our study into the capitalization rate study, which you're welcome to join me on that, but you needn't. But I am just going to point out that our capitalization rate study, specifically in our analysis, includes the application of the 5% non-recovered allowance. And the reason that's very, very significant is that if one disallows the 5% for any reason, that has the effect, and of course we have to use the same methodology, and that would have the effect of actually increasing our capitalization rates by between typically 36 and 39 basis points. So we have, in our capitalization rate analysis, we've been consistent with the inclusion of the 5%. We're suggesting this morning that the 5% should be restored in this case and the ones coming up. But if the board is not inclined to restore the 5%, then the capitalization rate, our request simply would be that the capitalization rate be increased by 40 points in order to reflect the fact that our analysis bumps up by that amount once the 5% is removed. So now, having said all that, if we go back to our original brief, and Madam Chair, with your permission, I won't repeat that part of the discussion on the 5%. I'd ask the board just to carry those comments through to the rest of the docket if we might. Then to go back to our page 13 with the income approach summary, with the application of the 7.5% vacancy to the NSC or neighborhood shopping center component, restoring the 5% allowance and applying the 7.3% cap rate, and then adding in, of course, the Tim Hortons and the gas bar income streams and adjusting for the gas bar improvements. Our suggestion this morning, as you can see on that chart, is a total assessment of $11,282,000. Thank you.
Thank you, Mr. Reimer. Mr. Fougere, do you have any questions?
Yes, please. You had mentioned as a primary reason for appealing the 2022 assessment was some revelations about the nature of some of the more tenuous occupants of this property. Is that correct?
That was definitely part of the discussion that the owner had engaged us in prior to the deadline. Absolutely.
Right. And I think our number differs slightly for the calculation of vacancy. Did you calculate that based on the number of days vacant in the year as well?
Oh, these were snapshots.
Okay.
So the chart on page 7, Mr. Fougere, is when we go through the years, that's basically the snapshots at the end of each of the calendar years.
Okay.
It's not a weighted average.
Right. And this is, just to be clear, this is amongst the vacancy amongst the neighborhood shopping center areas, not necessarily the whole property.
It wouldn't include the, and Madam Chair, to answer that, I'm going to go back to my page 13. It doesn't include the Tims, where we've applied a vacancy allowance of 3%. So it doesn't include that area, and it doesn't include the Domo Gas Bar, where we've applied a vacancy allowance of 2%.
Okay. So that was the snapshot of vacancy at the end of 2017 for the neighborhood shopping center portion, not the Domo and Tim Hortons in that calculated into that figure. And so that's what was physically vacant, as you mentioned. And then some of the details about, the short-term leases and the difficulties with some of the other tenants. Would you agree that that's, somewhat privileged information that for example, the assessment department cannot really be expected to be in the know, and perhaps even a prospective purchaser or an investor may not have quite that level of detail with the relationships of these tenants?
In the case of 3 of the 4 items, I'm going to disagree with that, because as I mentioned, Foster's specifically only agreed to a 1-year renewal that was expiring in August, and that's very much a red flag. In the case of Achilles, again, a 1-year renewal. And in the case of PharmaSave, while they wouldn't know all the events leading up to and all the efforts of the landlord leading up to the renewal, it was still only a 2-year renewal. So Mr. Fougere, your point's well taken, but I'd suggest in those 3 cases, it would be very obvious that those tenants were at high risk. The more difficult one is Joey's Only. So unless the prospective purchaser had, in connection with his due diligence, made some inquiries about that operator as of the reference date, that is information that without those inquiries, it would not be obvious. Those would have to come from very specifically as part of the due diligence with the landlord. We would expect them to that's obviously part of the due diligence process, is you're looking at the covenants of the tenants and you're getting information on it so you can gauge the strength of the income stream. That is one, though, that you would only buy through that due diligence process. You would only find out. It would not be obvious on the face of the record.
Okay. Just looking here. So your vacancy, you look back till 2013, is that correct?
Yes. In the chart there, yes, indeed.
Right. Okay. It's going to be a moment here. Yeah, I think those are my questions. Thank you.
Thank you, Mr. Fougere. Mr. McIntyre, do you have any questions?
I have no questions, thank you.
Mr. McPherson?
I just wanted to make sure that I understand what the difference is. First is your vacancy, and you've explained why that is. So you're looking for 7.08% versus the 3.89% that the assessor has used. Is that correct?
That's exactly right. Based
Okay.
upon specifically the 7.5% for the NSC component. Yeah.
Right. And the non-recoverables, you're suggesting it should be 5% and 2% for a total of 7 versus the 2% that the assessor has now suggested should be 5%.
Yeah, that's correct.
Okay. And you made a comment about the cap rate. If you said that the non-recoverables weren't reflected in their entirety that you're asking, you said that the cap rate should be bumped by a certain percentage?
But by 40, the minimum, what I'd suggest is 40 basis points, depending if you, and I won't go through this, but if you would choose to go to our capitalization rate study, and if you would back out the 5% and then the mathematical effect is anywhere between 36, 39, and 40 basis points. So we're suggesting in this case a bump of 40. So it would be from 7.3 to 7.7 if one excludes the non-recoverable expense allowance.
Right. I thank you. Thank you, Madam Chair.
And thank you. I have no further questions. We'll move to item number 4. This is 1220 St. Mary's Road. Mr. Fougere, whenever you're ready.
Okay, thank you. So the property is 1220 St. Mary's Road. The roll number is 0808-12-22140. And I'll just get you to take a look at the property starting on page 8. And so this is directly across from St. Vital Mall. It's a new development there you may be familiar with. So it has the Wendy's with the drive-through. It has the Assiniboine Credit Union with the drive-through ATM, I mean, as well as some CRUs at the back. And so this is a newer development, and you can see the pictures continue on if you wanted to look. Notably, it sold in 2014 for $12,425,000, and this was publicly reported. And I'm just going to have you, when you have a chance, to turn to page 25 of my brief. This is a page from the Artis REIT investment report. And so towards the bottom of page 25, you can see it says portfolio acquisition activity. And so Shops of St. Vital, which is the subject property, it says sold for $12.4 million with a capitalization rate of 6.11. And so at this point, I'll have you turn back to page 3 of my brief. And so I had this property in appeal with another agent in 2020. And this was my recommendation at the board. That agent agreed to it, and we basically didn't hear the property because they agreed to my recommendation. And so, as I just mentioned, it sold in 2014 for $12.4 million with a capitalization rate of 6.11. Here, our recommendation was based on the actuals in place. So these are the lease totals here. 4% vacancy allowance, the 2% other, and a capitalization rate of 7.15, resulting in a valuation of $9,926,000. The capitalization rate used here was model generated. It was reported at 6.11, but here it's reported as, we've used 7.15 as part of our model. And you can see on page 5 of the order, it actually does specify the recommendation presented by ATD and accepted by the applicant. So we've used the actuals here, and again, I've looked at all the years available. In this case, since it's a relatively newer property, I was able to look at all of the years reported for the non-recoverable expenses, and I'm just going to pull up what I have here. Bear with me. And the information that I have was that towards the newer part of the development, back in 2015, I had calculated a non-recoverable expense amount of 3.54%. I've calculated 3 years of, and then subsequently there's 3 years of it not breaking 1% of the rental income. And then I've looked post-reference as well, but I'll just say that our 2% is well supported by what is happening currently at that property and has been happening since its construction. So I think it's very defendable with the sale price that's been reported publicly, and the details of the assessment, and we're using actuals, and so we've had one agent agree, and my personal feelings aside, Mr. Reimer had mentioned my frustrations. My apologies if that comes through. Don't worry about my emotion when it comes to appealing a subsequent year of the assessment. I think it's a valid thing to do, and I don't mean to try to cast doubt on that. I think my caution is that I would hope that the panel would find compelling reasons to revise the assessment any further, because it has been revised already. So again, I apologize if I've come across in a frustrated way, but thank you. That's my presentation.
Thank you, Mr. Fougere. Mr. Reimer, do you have any questions?
Mr. Fougere, you always come across as professional and very well spoken, and the frustration was in your words, not your actions. So to be clear, I'll leave it at that. I have no concerns. With respect to, so we've got this price that you've alluded to, and this, though, what we don't know is what assumptions at that time, back in, I guess it was 2014, what assumptions that the REIT made when they valued the property, correct? Like, it's just the one line is all that we're looking at there, correct?
Correct.
Okay, and we can agree, and you've alluded to this very forthright, the reduction and the value of $9,926,000 that's under review this morning, that was based upon the agreement of a different agent and not Altus, correct?
Correct.
Okay, thanks, Madam Chair. Those are my questions.
Thank you. Mr. McPherson, do you have any questions?
Actually don't, thank you, Madam Chair.
Thank you.
And I have no
You have
questions.
no
Thank you.
questions. Okay, thank you. On to you, Mr. Reimer.
Thanks, Madam Chair. So if I could, and I'm hopeful that the board and Mr. Fougere have all 27 pages, if I could ask you to open our main brief and go to page 10, please. And that should be headed valuation summary when you get there.
Okay, is everybody on page 10?
I'm not yet, Madam Chair.
I am.
Okay, I'm there. I'm sorry, what page, Mr. Reimer?
Page 10, please. Again, PDF page 10. So in the valuation summary, again, this is very much sort of very similar to the previous matter in that our potential income is actually a wee bit higher, not much, but it's by about $9,000 higher than the department's put on it. And in this case, our vacancy allowance and our other parameters are the same, save and except for the non-recoverable expense. So this boils down to the discussion and debate around the restoration of the non-recoverable expense of 5%. As Madam Chair, as you can see there, we have included that in our expense allowances. And so we're asking for that to be restored. And we've also got signage rent that we've included in addition to the rental for the spaces themselves. And we've included that in our valuation. So as you can see there, in restoring the 5% allowance and capping it at 7.15% on the assumption that the allowance is restored, but including the signage rent, then we come in at $9,773,000. So in fairness, where our value in this particular case is actually very close to the value that Mr. Fougere had previously calculated. Notwithstanding that, we believe the 5% allowance on principle is very important, and we're asking the board to restore it in this case. Thank you.
Thank you, Mr. Reimer. Mr. Fougere, do you have any questions?
Yes, please. Did you calculate any of the non-recovered expenses for your analysis here?
Our analysis, so to be clear, the non-recoverable expense study and the information that we presented in that study, that's what we're using to as support for including the 5% in every case. I think, as I had mentioned previously, and you alluded to it, Mr. Fougere, there's going to be some years when the allowances will be actually at zero, not just less than 1%, they'll be at zero or something very close to it. And then there will be other cases as some of these spaces in this mall perhaps go vacant. And as you alluded to, it's a newer mall, so that hasn't happened yet, but as some go vacant, you're going to see the leasing commissions costs go up, you're going to see the advertising costs go up, and so on a stabilized basis, based on the data that we've got in the study, we believe 5% is appropriate. But no question, Mr. Fougere, that the actual looking at the specifically 2016 and 17 leading up to the reference date, the actuals in this case are lower than 5%, and it makes perfect sense because they haven't had the need yet to start releasing space and spending a lot of money specifically on commissions and other inducements.
Right. Okay, thank you. Those are my questions.
Thank you. Mr. McPherson, do you have any questions?
I have no questions, thank you, Madam Chair.
Mr. McIntyre?
No questions, thank you.
Okay, that's great. All right, so we will move on now to item number 5. This property is 827 Dakota Street. Mr. Fougere, when you're ready.
Okay, thank you, Madam Chair. 827 Dakota Street, the roll number is 0802099850. And Mr. Reimer and I have been discussing all the properties today, but In particular, this one as it relates to an exemption request for one of its tenants, which is the Uville Clinic. That occupies approximately 6,000 square feet. And Mr. Reimer and I are in agreement that we would offer the exemption status for that portion. And we've calculated same amount. I'm just going to bring it up here. Mr. Reimer has it broken down in his brief.
If it helps, Mr. Fougere and Madam Chair, it's on page 2 of our submission, the breakdown that we're suggesting.
Thanks, Mr. Reimer. Yeah, so on page 2 of Mr. Reimer's brief, you can see the breakdown there and the class code for that exempt portion being class code 40S, school tax exempt. So we're in agreement with the valuation and we're in agreement with the exemption here. So we would recommend that class code 60 have a portion of 20,088,000, and then class code 40S have a portion of 1,543,000 for a total assessment of 21,631,000. Thank you.
Okay, so I'm clarifying that there's no change to the overall total assessment, correct? It's at 21,631, no change to that?
Correct.
Can you please explain what this 60S or 40S is? This little
sure.
exempt?
Sure. So this that portion refers to an exemption based on basically taking care of the ill members of our society. I think.
Madam Chair, Mr. Fougere, do you mind if I jump in and just refer the board to some of the materials that I submitted to you and the board to give some background to the exemption?
Yeah, that's a good idea, Mr. Reimer.
Madam Chair, may I do that?
Yes, please.
So if we could, on our submission, then if we could go to the PDF page 5, please. And again, if the board members might let me know when you're there, and then I'll continue.
I am there, Madam Chair.
And I am there as well.
Okay, go ahead.
So definition of the issue there, got liability taxation. What this is mentioned by Mr. Fougere, is the Uville Clinic. So they occupy 6,000 square feet, which is about 7.13% of the total leasable area. They're a nonprofit, and that is key in this case. They're a nonprofit registered charity that runs the community health center for people in the area. There are, and I'll refer the board to the page numbers at the conclusion of this. They offer a number of services relating that support both the physical and mental health of members of the community. That includes a teen clinic, basically a counseling service for teens who are having to help provide mental support for teens, seniors program, pregnancy support, diabetes program, and a counseling program, among others. So the exemption that Mr. Fougere and I are suggesting this morning is based upon Section 23(1)(e) of the Municipal Assessment Act, which says that real property is exempt for school purposes where the property is owned or held in trust for and used by a charitable organization, which they are, primarily for the purpose of giving relief or assistance to aged, indigent, or sick persons. And certainly we concluded that the Uville Clinic in this case falls squarely within those parameters. I note that also the Uville Clinic's got another location at the Dominion Shopping Center where the exemption was already applied. But we looked at this one certainly independently. And so I won't walk you through it all, but if you choose to do so, all of the materials talking about the various programs and Uville as an entity, as a nonprofit entity, it starts on the PDF. I'm just going to get to the front of it here. The PDF page 26, and that starts then with confirmation from the federal government as to the registration of themselves as charities, and then all the programs that provide mental and physical health support to the community members in the area follow after that. So we concluded, and Mr. Berger and I had a chance to talk, and we all both concluded that they do fall within that 23(1)(e), and that's the basis of the exemption request this morning. Thank you.
Thank you very much. Do either panel member have a question about this before we move on?
I have no questions, Madam Chair.
Mr. McPherson?
No, I have no questions, thank you.
And I'm just noting that both the assessor and the applicant are in agreement.
Indeed.
Okay.
That's appropriate. Yeah, absolutely.
Thank you. Okay, the last one on our docket today, 1765 Candiceton Boulevard. Mr. Fougere, whenever you're ready.
Hey, thank you, Madam Chair. So the address here is 1765 Candiceton Boulevard. The roll number is 0309-144-9900. And I previously had a recommendation in 2020 at the board, which was agreed to by the agent for a value of $10,335,000. I am actually recommending that we reduce that further here, down to a total of $10,199,000. And the reason for my revision here is the correction of some areas that we have calculating the rent. So we've corrected a few of the areas, and it's brought the value down a little further. So I believe it was an artifact from having, when we first put the building on the roll, as the units were coming online, we didn't have the final numbers perhaps, and we've revised them to reflect the leases in place. And so our recommendation is $10,199,000.
Okay, thank you. Mr. Reimer?
Thanks, Madam Chair. I have a slightly lower value. Appreciate the recommendation. My value is a wee bit lower still, so ask to proceed briefly, although the issues are going to be confined to basically a single issue.
Okay, so go ahead, Mr. Fougere.
Right. So so I took a look at this property as well in terms of what the actual non-recovered expenses are, and I think that's where our disagreement lies. Just bringing it up here. This is a case, as previously discussed, where bad debt and vacancy and operating expenses that weren't recovered because of vacancy made a significant impact on the total percentage of non-recoverable income. But once that was sussed out, the percentage of non-recoverable income is significantly lower, and it varies from year to year, as Mr. Reimer has pointed out. But it's much closer to the 2% other that we have, and so we're sticking by our assessment in terms of the 2%. That's my presentation.
Thank you, Mr. Reimer.
Thanks, Madam Chair. I actually, on this one, I have no questions. I'll get straight to the issue in a moment. Thank you.
Thank you, Mr. McPherson.
No, I have no questions, thank you.
Mr. McIntyre.
Just one question. There's two income streams on this property?
No, I just, unfortunately, the number of premises, wouldn't fit on one sheet. So I had a second sheet, but they're the same income stream, just split so that you can fit it on one page and not have tiny font.
Yeah, it just looks kind of odd when you've got two income evaluations on each
Right.
each sheet. So okay, no, that was my only question.
Mathematically, it is the same.
Okay, thank you.
Thank you. Okay, Mr. Reimer.
Thank you, Madam Chair. Could I ask the board members, Mr. Fougere, to open our submission and please turn to page 9 of the PDF. And again, that page should be entitled Valuation Summary at the top.
Is everybody there?
Yes.
Okay.
So the only issue here is the non-recoverable expense allowance. And certainly we, for the reasons we suggested in our submission on concerning the issue, we're suggesting the 5% should be restored. And as you can see there, that then results with the potential income, I should explain, is we're within $2,000 of each other. So it's very, very, very close. We're agreeing with a 4% vacancy in this case. The other parameters, shortfall, other structural allowance at 2% and the cap rate at 7.15%, providing that the 5% non-recoverable is restored. We're in agreement with those, and so it comes in at $9,765,000. Again, just to remind the board, if our capitalization rate analysis includes the 5% expense allowance, so if it is for whatever reason disregarded in this case, then our request would be to bump the cap rate by the 40 points to 7.55%. Thank you.
Thank you. Mr. Fougere, do you have any questions?
Yeah, just one. Mr. Reimer, did you look at the actual non-recoverable expenses at this property?
Absolutely, I did. And certainly, so actually I'm going to bring up a point of clarity. Madam Chair, if we could go to, in my submission, to my page 20 of the PDF, please. And what you should see at the top of that is the 2017 first page of the income statement.
Okay.
So now this, I should explain, this is a combined income statement. This property that's been assessed under this roll number, there's a few roll numbers that are included. It's basically that entire sort of mall on that includes this property and the properties further west. So the income, the total income from all roll numbers is actually $4 million. But what I was going to clarify is, because it isn't obvious, Artis REIT is of course, as a public entity, they are bound by the IFRS accounting standards and are obliged to report under those standards. And so what the reason I'm telling you, the board members and Mr. Fougere, this is that the structure of the report and the categories of expenses aren't always obvious. And what we're able to determine, and Mr. Fougere, just for your reference, there on that page I'm showing you, the 5th line down is something called amortization of tenant incentive. That is specifically related to an IFRS standard and basically a label on it according to that standard, but that does include the leasing commissions that are paid. So that $114,970, they're reporting it differently than what, for instance, we saw in that first property of 560 Pembina, where it's very cleanly set out. But that amortization of tenant incentive, when you see that, does in fact relate to the leasing commission. So one has to take a look at that. And also then on the next page, following that on page 21, there are something called owner's expenses, where they show non-recoverable operating costs, appraisal fees, which relate to the professional fees we have in our study as well. So it's split out a little differently. So I guess that's the long answer, Mr. Fougere, but I wanted to make you aware of that because it isn't obvious where the leasing commissions are going, and that is where they're going. But again, no question that in this case, for the entire property, all the roll numbers, it's less than the 5% in this given year, but that fluctuation is to be expected. Thank you.
Mr. Fougere, do you have any other questions?
And just a follow-up question. We can't quite distinguish what the leasing commission is from the rest of the tenant incentives. Is that correct?
That is correct. There is no specific number out of there. Now, if you recall from the study, the objective is to get to a stabilized number, which is, and we're suggesting the 5%, that reflects all of the various elements of non-recoverables. And so my suggestion would be the leasing commissions are in that number, and there's other items in there. I have no doubt about that. But certainly those are the kinds of non-recoverable expenses that an investor, I think, would stabilize on the income stream. But to answer your question specifically, I don't know how much of that 114 grand is leasing commissions in of itself. It could theoretically be 100% or something less, but I don't know.
And I believe you mentioned earlier that the municipal board has some direction on not allowing deductions for, free rent, tenant incentives. Is that correct?
Yeah, well, no. That not the allowance is something very different. What the municipal board has said is you can't take it dollar for dollar to calculate a net effective rent. And again, to stress, Mr. Fougere, we're not suggesting that. If we were suggesting that, then what you would see in our valuation summary is a top line deduction, dollar for dollar, sort of year in and year out. And we are absolutely not suggesting that. What we're suggesting is that the 5% non-recoverable expense, which is a stabilized expense that's, again, we're suggesting borne out by the data, an appropriate stabilized expense to account for all of these non-recoverable items, leasing commissions usually being one of the most significant. But we're not calculating an NER and not contradicting those municipal board decisions.
Okay, and then just final question. Did you look at any other years for this property in terms of the non-recovered expenses?
I didn't do a historical analysis of this property. No, I'm relying upon our study, the study that goes through all the data to support the 5%.
Right. Okay. Thank you very much. Those are my questions.
Thank you very much. Mr. McPherson, do you have any questions?
I guess a learning opportunity here. You referred to IRFS. I'm assuming that's got something to do with a REIT.
It's the International Financial Reporting Standards, and so public companies. And I'm not an accountant, so I don't know exactly. It came in, I think, roughly 8 years or 9 years ago, and so there is a specific set of standards that public companies are obliged to follow under the name IFRS, International Financial Reporting Standards. So that is what Artis is obliged to follow and have been. Yeah.
Thank you. That's all I have, Madam Chair. Thank you.
Thank you. Mr. McIntyre?
And I have no questions. Thank you.
And I have no questions either. So thank you very much, Mr. Fougere, Mr. Reimer, for today's hearing. And we will have our decisions to you shortly.
Thank you all for your time and have a great weekend.
Thank you.
Thanks, guys.
This meeting is now adjourned.
Thank you.
Thank you.